So another option that's very common. We did a ton of these. Was it 2 years ago when the exemption? We 2012 is when it was. The exemption was $5 million going to drop off at midnight to $1 million, and so anybody with assets in excess of this $1 million wanted to get take advantage of the $5 million, but didn't want to give everything to the kids. And so we were able to move those assets, make them completed gifts, file the estate tax returns, and get that growth out of the taxable estate. And so it's all a matter of drafting as to what powers you give up and what powers you keep as to whether or not it's a completed gift or not. But that's kind of what we're working with in doing that from the tax standpoint. Other liability protections besides trusts, certainly your line of first defense is going to be some kind of umbrella policy. I don't ever want to be seen or as saying that trusts and LLCs and all are the first line of defense. These things are just in case everything falls apart. Your first line of defense really ought to be on the insurance side, because you want to turn, you get sued, you want to turn it over to your insurance carrier and have defense counsel take care of this and hopefully have them write a check and not have to deal with these things. Doesn't mean don't do the other, because the liability that you have may be much higher than your policy limits, in which case then you don't want all your assets being lost. So you still do these other things, but they're not a line of first defense. So an umbrella policy certainly is something all of our clients need to have in place if they're looking at doing this type of thing first. LLCs and limited partnerships are also tools in the toolkit that we look at for protecting against liability. And the concerns that we really have, we can do multiple things with them. Number one, for estate tax purposes, we can have an impact or dramatic impact on the value of assets by putting them into these entities. So we can put assets into an LLC and make the LLC worth less, or at least our share of the LLC worth less than the underlying assets that we stuck in there. And we do that by putting restrictions on how the LLC might be managed, on voting rights, on having minority discounts, on putting limitations on who you could sell to, and all these other things that make perfect sense for managing an asset in a family arena that we want to keep in the family arena. These are all reasonable things to do, but also have a dramatic impact on value, the reduced value. And so if we have an estate tax issue, we've now reduced taxes by reducing value of those assets. We also, though, get creditor protection in doing that, because the assets inside the LLC is a separate entity. And so if that LLC produces liability, that liability is going to be contained inside of that LLC or corporation or limited partnership, and not going to I got a shawl in my car now. So the goal is to contain that liability inside of that entity, rather than take a risk of it affecting personal assets. And so if I've got a rental house, if I own the rental house personally, the rental house blows up and kills 3 people because I didn't maintain the gas line, guess who's getting sued? And guess whose assets are going to be on the line, because I don't have enough liability coverage to cover that lawsuit, right? But if it's in an LLC, well, I probably lost the rental house. I lost everything in the LLC. But my personal assets are separate and apart from that, and so we're trying to contain that liability. And so that's an important feature, from an asset protection standpoint. You can layer the LLC and layer the functions in the LLCs to further segregate and further segment liability, between entities. And so it depends on the liability risk that's out there. It depends on the assets that you're dealing with out there, as to how complex that you want to make it. You can make it too complex. I mean, I had, most of you probably know, I took over Walt Dallas's practice, I guess about a year or so ago. And so Walt is, a master at this type of planning, helping with liability protection and such as that. And, I had a client come in saying, I don't understand any of this. I just want to get rid of it. I want to make it simple. And I said, well, let's understand what you got first. And there was a pile of documents. It was this LLC and this LLC and this trust and all this. And so when I flowcharted it all out, what we had was entities. This farm was in this LLC. This building was in this LLC. This LLC here managed these 2 LLCs. The interests of these were owned by certain trusts and such. It's sounding complicated, right? But what else I found was that this person was having school children out to this farm riding horses. And these weren't just any school children, these were special ed school children out riding horses. I said, well, that's that's why these things are layered like this. Is you've created, liability waiting to happen here, and so what they're doing is containing that liability there, and you're not personally managing it. This company here is personally managing it, and so when liability occurs here, they may get everything in this bucket. They may get everything at the management side, but they're not going to take your building. They're not going to take your practice. They're not going to take your personal assets. And so if we've got to have a few entities and file a few annual reports and maybe have money flowing for tax, for income tax purposes in order to these different accounts in order to do that, it's well worth it because of the liability that you're taking on. And so it's a weighing factor of is the hassle factor of the complexity worth the protection? And if you have serious assets at risk and you're doing high liability things, then absolutely it is. And so it's just a matter of understanding it. On the other hand, you can do overkill and take something that should be fairly simple and make it way too complex, and then the person doesn't know what they're doing, doesn't follow the rules. Now it's going to all get breached through anyway because you were writing checks from here to pay for things over here that they didn't have any interest in and things. So there's a weighing factor. You've got to weigh the liability and the risk against the complexity of it and make sure that it's worth the hassle factor. Family limited partnership is a common way that we use to segment liability and to reduce asset value, because inherently inside a limited partnership is the limited partnership interest that doesn't have any voting rights, which gives us a really good excuse, really good reasons to not to reduce value of that, as far as the value that we're putting on that. And so if we're making a gift of some of those limited partnership interests, we automatically get some really good discounts on that because they're automatically not having control factors, or that those limited partnership interests can't control who is in charge of that entity, and so as a result, we get low interest, lower values of that. It also helps because a lot of times what we're doing is families, in family scenarios, the person that's doing the gifting out still wants to be in charge. Usually it's dad, and he's willing to give pieces of the equity out to the kids to get out of their taxable estate, but he's still got to be in charge. And so the limited partnership, we can put an entity in place that he controls that is the general partner. He's still in charge. He's not giving up any of the control. He is giving up equity at a significantly discounted value. So now we're getting parts of the estate out, and sometimes we sliver those interests out to be valued at $14,000 per person per year to fall below the estate, below the annual exclusion amount. So we don't have to file a tax return on that. We don't have to use up any of our unified credit. When it was $1 million unified credit is a big deal, but even at $5 million, we don't want to use up any of it unnecessarily. And so we get those assets moved down year by year and still keep control up here.
Do you have to do any paperwork?
Are we just giving cash or are we giving interest?
Cash.
No.
Okay.
I mean, cash is, it's worth what it's worth. And so we don't have to worry about the value of it.
You don't have to report that on the income tax return
Unless you're below the 14,000. I don't think it's gone to 15 this year. Does anybody know? I haven't seen anything.
do a split gift.
You can do that. You do 28. Yeah, that's right. But you do have to elect to do that. That's correct. So if you're doing gift splitting, you would have to. But other than that, there's no actual reporting to do. If you're giving an entity, so I've got an LLC interest. It's worth $1 million, but I'm going to give away a 1% interest in this LLC, but it's going to be discounted. I've got to get a valuation on that, what that sliver interest is worth, and then make the transaction that way. So I've got to paper that transaction. Now, whether I choose to file a return or not on it is, do I think the service is going to challenge my valuation or not? Because I don't want them challenging it 10 years from now. If they're going to challenge it, I want it done now. So I'm going to probably file a gift tax return, put my valuations on there, and start their 3-year clock running. So that's, in those circumstances, usually you do want to paper the transactions. If for no other reason, because 10 years from now, you might not be around, I might not be around, and they don't know what we did. How did this get from here to here? And so if we paper that with a buy-sell arrangement in that, then they can understand, oh yeah, this is an arm's length transaction, this is the value they put on it, this is what occurred in that transaction. So we're all familiar with inside creditor protection. That was my example of the house blowing up and my personal assets being protected. The other place, though, that LLCs can come into, can be beneficial is with outside creditor protection. Outside creditor protection is is a creditor that occurs outside of the entity, not a creditor that occurs from inside the entity. So I'll give you an example. We got the Joneses and the Smiths, and they're going to open up the Jones Bakery. The Joneses are the general partners. They know how to bake, but they don't have money. The limited partners, the Smiths, have money, but they don't know anything about baking. So they're going to take limited interest in this entity. They're going to just be investors. And so they each put money in the business. It's going along fine until the bakery truck rams into a busload of school children. And now the entity gets sued, and it gets sued for way more insurance than it has. And now we're going to lose all the assets in the entity because the entity is liable. We have vicarious liability. And so the fact that neither one of the owners were driving the truck doesn't matter. The entity itself is at risk, but it's only at risk. So they can't pierce through the bakery to get to the Joneses' assets or the Smiths' assets. Okay, so we're all familiar with inside creditor protection. Outside creditor protection refers to when the event that gives rise to liability occurs outside of the company, to one of the owners. So one of the owners rams into a busload of school children, kills them all, we get a $20 million lawsuit against him. Now, plaintiff lawyer is looking for assets to collect against. And one of those assets is a 50% interest in Jones Bakery. And so can he take that 50% interest in Jones Bakery and force a sale of that interest? Or step in the shoes and now vote that 50% share to vote himself on the board to then do things like force a dissolution of the company and things like that. That impacts the other owners of that entity, of the bakery. And so if the papers are drafted properly, we can limit the ability of an outside creditor from being able to come in and wreak that kind of havoc. If you have a non-entity, you don't have any control over that. In other words, if this was a general partnership instead of an LLC, or a general partnership instead of a limited partnership, a general partnership can be dissolved at the will of either one of the partners. And so when that judgment comes down and they do a judgment creditor exam and they collect against the asset, that 50% interest, he's now a shareholder or partner in that business now, and he as a partner can force the sale of everything and get half of whatever the sale proceeds are. We just wreaked havoc on the other investors in this business. If it's an LLC though, and that LLC provides that new members don't have any voting rights unless the other members unanimously agree to give voting rights to those new members. A creditor claim can only be a charging order against the interest, can't take the interest itself. Now we've put in protections that will limit the ability of this tort claimant to come in and take those shares. At best, what they're going to have is a claim against the company that say, hey, if you ever pay Mr. Jones any money, you've got to send that money to me until this $20 million judgment is satisfied. So, if a distribution is made, it's got to be made there. But I got no rights to come in and vote his shares. He's still in charge of voting those shares. I've got no rights to come in and force a dissolution of the company because the company itself is a separate entity. That outside creditor protection doesn't do anything for Mr. Jones, but it's doing protection for the other shareholders, the other LLC members of the entity. And so it's important from that aspect. And so we can use those concepts to provide protection for our clients, including family owned entities. And so we want to design our entities where we get that outside creditor protection. And we can layer those protections that we've talked about with trusts, combining those with the creditor protection with outside creditor protection. So for instance, we can create, I'll give you an example. Okay, so a group of doctors here own this practice, and there's 3 of them here, and they equally own this entity. And we're worried about liability, so we put that entity inside of an LLC, but they're equal 1/3 interest holders in the LLC. This guy over here gets a creditor claim against him, and so we get a charging order against the LLC. Well, if we draft the LLC properly, they can't come in and force a sale or dissolution of the LLC. And as long as the LLC holds the money here, it's never going to the creditor down here. CREDITR, right? It's never going to the creditor here. But it's not getting to these guys either. We can't make unequal distributions. They're equal owners. And so if money comes here, money's got to go here and here, but his money's coming down to Mr. Creditor down here, right? And so, what can we do to eliminate or, further deal with that? Well, instead of our person here being the owner, what if we had his share of it owned by a trust that he's a beneficiary of, and his wife's a beneficiary of, and his 2 children are beneficiaries of. And so now we still got the same creditor claim out here. So Mr. Creditor's down here. And he has a charging order against, this trust interest here. So he says if you have any money, it's got to come to us. So LLC distributes money to these guys. So money's here, and money's inside the trust. But the trust didn't do anything. So my creditor claim is against this guy here, if he's owed something. So Mr. Trust, if you distribute money here, you got to give it to us. But wife didn't do anything, we can distribute to wife. Children didn't do anything, we can distribute to children. And so we have a way of getting money out, not forcing it to come out where it would be forced to come to a creditor. We've got controls over where those assets can go by drafting a trust properly that has multiple beneficiaries, that again doesn't violate our rules of self-trustee, self-beneficiaried, self-created trusts. And so again, we can layer these concepts of an LLC or a limited partnership together with having ownership of those inside of trust to provide further control and further protection over these types of assets.